This video is only meant to provide general legal information and is not legal advice. Before you take any action or rely on any information in this video, it is recommended that you consult an attorney or contact the Legal Aid Society of Hawaii. This video provides information on resources for court users, including court self-help centers, language services, mediation, and accommodations for people with disabilities. Court self-help centers and access to justice rooms are available to help court users with legal information or advice. Working together with the Hawaii State Judiciary, the Hawaii State Bar Association, and the Legal Aid Society of Hawaii, volunteer attorneys and AmeriCorps advocates staff the court self-help centers. For more information or schedule of the self-help center near you, please visit the Judiciary website at www.courts.state.hi.us. The Hawaii State Judiciary recognizes that many people who come to court may not be able to fully participate because of language barriers or speech or hearing impairments. The judiciary has dedicated many resources to enhance language access services for court users. These include providing court interpreters for all defendants, parties, and witnesses in all case types, and provided language services at all points of contact with the judiciary, including over-the-counter and over-the-telephone encounters. The court provides free interpreters for all participants in court hearings. The court also provides free language services to help you communicate with court staff outside of the courtroom. If you need help in your language when you visit or call the court, tell court staff you need an interpreter. You can also ask for a language ID card, which is also available on the judiciary website or at the courthouse. To request an interpreter at your court hearing, you must go to the court to see the judge on your hearing date. At the hearing, you may ask the judge for an interpreter, give the judge a letter asking for an interpreter, show the judge your language ID card available at courthouses and on the judiciary website. Your attorney may ask the judge for an interpreter for you, orally or in writing. At your hearing, the judge may ask you questions. The judge will decide whether you may have an interpreter. If an interpreter is provided by the judge, the interpreter is free. The Hawaii State Judiciary is committed to providing equal access, consistent with the Americans with Disabilities Act, the Americans with Disabilities Amendments Act of 2008, and other state and federal laws. If you have a disability that may restrict your ability to meaningfully participate in court proceedings, programs, and/or activities, the judiciary will provide you with appropriate accommodations. You can request an accommodation by contacting the Disability Accommodations Coordinator assigned to the courthouse where your hearing is scheduled. A request for an accommodation may be made at any time, but you should let the court know at least 10 business days in advance. Requests for accommodations may be oral or in writing or by email to adarequest@courts.hawaii.gov. The Disability Accommodations Coordinator will complete a request for accommodation form and act as the facilitator for your request. The court is required to find an accommodation that will effectively allow full participation in the court proceedings and/or judiciary programs, activities, and services. The court is not required to provide the accommodation of your request, but must provide one that ensures effective communication. Determining an appropriate accommodation requires open communication between you and the Disability Accommodations Coordinator, during which your input and suggestions are welcome and important. Alternative Dispute Resolution, or ADR, is another resource to consider before going to court. ADR is an alternative to filing and moving forward with a lawsuit. After a lawsuit goes all the way through trial, even the winners may feel they have lost. The costs and time commitment on both sides may be enormous. Sometimes neither side is satisfied with the result. On the other hand, ADR may help you settle all or part of the dispute much faster than trial, save you time and money, reach more creative and mutually acceptable solutions, and preserve relationships. Some of the ADR alternatives the court offers are non-binding arbitration mediation and settlement conferences conducted by judges. Each of these will be briefly described, and you should keep your case in mind in considering which one might be best suited for your situation. You should also consider contacting community mediation centers or private sector ADR providers to find out more about the services they offer. Arbitration is usually less formal, less expensive, and faster than a trial. Instead of going before a judge, disputing parties agree that they will be bound by the decision of an impartial person or arbitrator. The arbitrator listens to opposing parties in a dispute and renders a decision. Mediation is an informal and private process where a neutral third person, a mediator, helps the parties explore solutions. The mediator meets with all sides, together and separately, and uses a variety of techniques to help the parties come to a resolution. The mediator works to improve communication between parties, help parties clarify and communicate what they want and understand those of the other parties, identify areas of agreement, and help generate options for resolution that both sides can agree on. The mediator has no power to impose a settlement and does not influence a party to accept any proposals. If no settlement is reached, the case remains on the trial track. Fees differ. There's generally no fee for mediation provided at the courthouse for small claims and residential landlord-tenant cases referred by judges. A settlement conference helps the parties in negotiating a settlement of all or part of the dispute. A judge helps the parties negotiate, and some settlement judges also use mediation techniques to improve communication among the parties, explore barriers to settlement, and help develop resolution options. Settlement judges might express views about the relative strengths and weaknesses of the parties' legal positions. Often settlement judges meet with one side at a time, and some settlement judges rely mostly on meetings with the attorneys. For more information about ADR and a list of community mediation centers, please visit the Judiciary website at www.courts.state.hi.us/CADR. For more information about any of the services discussed in this video, please visit the Judiciary website at www.courts.state.hi.us or call the Judiciary's Communication and Community Relations Office at 808-539-4909. For other resources, including legal information brochures and interactive interviews, see the additional information section below. Remember, this video is only meant to give general legal information and not to give specific legal advice. For more information, call Legal Aid Society of Hawaii at 808-536-4302 or visit www.legalaidhawaii.org.